Well, I think we'll go ahead and get started. I'd like to introduce your panel to you. This is Joseph Downs. Joseph is the managing member of U.S. Mortgage Resolution and is a client. This is Dave Sutherland. Dave is a forensic accountant out of Scottsdale. He works with our firm and with the firm in Scottsdale, doing forensic accounting for us and analysis. I'm Joe Dickerson. I'm president of Financial Forensic Services. I've been doing this one way or another for about 53 years. You've been around for how many?
Yeah, I've been doing civil and criminal investigations for the better part of 15 years. I was a law enforcement officer for 7 years with Phoenix Police Department doing white-collar crimes investigations and every other type of criminal case you can think of. And then I left law enforcement in 2009 to do forensic accounting solely. And our firm, we're a boutique accounting firm, so all we do is forensic accounting. We do a lot of commercial litigation, litigation support, insurance claims. But on the topic of what we're talking about today, we do a lot of cash flow analysis and identification of assets and even hidden assets through the documentation. So
we're recording in here, so we need to speak into the mics for the record.
okay, fair enough.
Very good.
Too loud.
All right, thank you. Joe, you want to give them a little of your background before we get started?
Sure. These guys sound really smart. I'm just the dumb debt buyer.
Yeah.
My background is in real estate securities and finance, mostly real estate finance. Got into debt buying about 8 years ago. Just saw an opportunity to buy a lot of the residential debt that we had access to. And that kind of morphed eventually into buying commercial debt through some of our relationships. And wouldn't have done so had I not met Joe at some of the conferences that we attend together.
Great.
But glad I did. Sorry. Not loud enough?
All right. And my background, just to expand a little bit, I was a detective sergeant on the Houston Police Department, worked white-collar crime, and then the chief of police picked me and my partner and transferred us to the district attorney's office. And with his top of 5 assistants, the 7 of us formed the Organized Crime Bureau in Texas back in the early 70s when the boys from Chicago thought they were going to take over Texas. And then I left the government after 11 years because my off-duty work was doing consulting work for the oil and gas companies and the manufacturers and distributors of equipment. So got to where I was making 5 or 6 times as much off duty as I was on duty, and going to work was interfering and making a living. And didn't want to have a conflict or a perceived conflict, so I left to devote full time to my business back in '75. And then when the bottom dropped out of the oil market in '84, I found myself with practically no clients left. The ones I had left were hoping their stuff would get stolen so they could collect on their insurance. They sure didn't want me recovering it for them, so I had to rethink my practice and had a pretty good run, had a vacation home in Colorado that I planned to retire to, so I moved up there to get started again. And the first client I got of any real consequence was the legal department of FDIC. There may be 1 or 2 of you in the audience old enough to remember that era. And FDIC and RTC were taking over the failed savings loans and banks, and I became a consultant for FDIC and found that they had thousands and thousands and thousands of judgments on the books, but they did not have the expertise nor the manpower to enforce those judgments, so that fell to me and my staff. And then they would assign one of their staff attorneys, a paralegal, and a staff investigator to augment my staff, and we worked together to enforce those judgments. And during that time, we did a little research and found out that 80% of the civil judgments in the United States are never collected. And the light bulb started flickering and finally came on, and I said, heck, that's a business and nobody's really doing it. So we just revamped our company, and since the late 80s, I've done nothing except either pre-judgment due diligence or post-judgment forensic research to find hidden and diverted assets around the United States or internationally to satisfy judgments. And like Joe said, we met, and he and his clients started buying portfolios of judgments and bringing them to our firm to enforce for them, and then we brought Dave in to help us with some of the analysis work and so forth. So that's how we got to where we are now. Joe, you want to talk a little bit about the parameters of purchasing judgments and how you decide on what you're going to buy?
Sure. So typically how the process begins is we were in a position we had a pretty strong relationship with certain banks, and they actually approached us about buying some of their commercial judgments and notes. To that point, this was a couple of years ago, to that point we really just bought their residential debt, residential mortgages, I should say. And we certainly weren't going to do it unless we knew what we were talking about, or at least how to do the due diligence, and someone else knew what they were talking about. So through various conferences I mentioned, we had some interesting conversations with Joe and his colleagues at Financial Forensic Services, and it became pretty apparent that if we were to buy the judgments, we would have a partner, but the question then was, well, how do we buy them? So typically when we're analyzing debt and the residential side, which we frankly compared to banks, we're experts at it, there was a lot of overlap, but then certainly some nuances. So when the bank hands us a portfolio, it's typically an Excel spreadsheet. They call it a file, whatever, pool, you've heard those terms, but it's an Excel spreadsheet, really, at the end of the day, with I don't know how many columns of data. A lot of it, we were used to seeing, a lot of it was a little newer, but our then challenge is to take this information and to dissect it and understand it in a way that we would normally understand a residential portfolio, with what I'll call limited resources that we have. So we then go into what Joe's calling a spot audit here of due diligence. There's certain things that we look for in each tape, and then certain things we can go back to the bank and request more information for. But in that, we're looking certainly for everything in front of you here, but what's the average balance? What's the minimum? What's the largest judgment in the portfolio? What is it going to cost to try to collect on these assets? Where are they located? Has the bullet point here, has the seller recovered any asset? That means what is the bank done to this point to collect on these judgments or notes prior to becoming judgments? So that's actually an interesting point, is are we talking about a judgment that they've actually filed and recorded somewhere, or are we talking about something that's still a note but in default and certainly headed towards a judgment if we want to continue it? What assets, if any, are these notes or judgments attached to, both at origination and then currently? Are there any other guarantors? In other words, in a commercial loan file, you have a borrower, which could be a person or an entity, and then hopefully personal guarantors of the borrower or the borrowing entity. So who are they? How many are there? What is the age of each file? In fact, when was the last payment made? So what we're looking at there is what's the statute of limitations, if any, on the debt. So that's a state-by-state issue. So there's certainly, at the spot level, there's a lot of information we have available to us, and we then take that information and say, well, what do we know to this point, and is it worth it to then take it to the next level, to assemble a team to really spend the money to do due diligence, because again, we're only looking at the surface information, what's provided to us, or again, with our resources, what do we have to find out? But I got to tell you, when it comes to this stuff, all we're able to do is really the tip of the iceberg. And then the next question, as a debt buyer, you have to ask yourself is, do you want to take on this task manually in-house, or do you want to put together a team that can not only dig a little deeper into what I'll call the iceberg, to help you understand how to price the portfolio and what your range of collection is. But then if you make the decision to buy it and negotiate it with the bank, now you own it, it's dog chases car, dog catches car, now what scenario. So
Dog
that,
bites the tire.
what's that?
The dog bites the tire.
Dog bites the tire. So, you really, as a debt buyer, have to be comfortable with not only pricing it, acquiring it, but then going after it and collecting it. And that's where you can do that in-house and assemble a team to do that in-house. Or in our situation, we were fortunate enough to meet Joe and his team, and he already has the team assembled. And if he doesn't, it's a simple plug and play in this state with this attorney or that attorney. Because I think at the end of the day, a lot of what we do not only comes down to forensic accounting, but there's a lot of legal work involved.
Thank you.
Sorry, that was long-winded.
No, that's fine. As he said, we do the forensic research to find the assets, and we'll talk about and show you how we do that. But once we find them and we're ready to move forward, we will select and hire the attorneys for our client. They actually sign the engagement letter, but the way we manage and control the cost on that is the attorneys that we engage are directed by the clients in the engagement letter to take their instruction from my firm and to submit their invoices to us for approval before they're paid. Because we have situations where you may have a partner in a law firm, he'll call in an associate, they'll call in a paralegal and maybe a clerical person, and they'll sit around for an hour or two talking about the case and who's going to do what. And just last month we got a bill for billing 4 people for the same hour, and I called him up and chatted with him about that and explained to the partner that we would pay his rate, but we weren't paying him to train his people and manage his people on my client's money, and we cut a little over $3,000 off the top of that one invoice. So we try to move expediently and as quickly as we can, or in many cases we've been fortunate enough to be able to get significant settlements without even having to bring a law firm in, because they buy the portfolios at a pretty steep discount and give us the latitude, subject to their final approval, on negotiating a settlement price. And if we can do that without spending thousands and thousands of dollars on legal fees, it usually works out pretty well. And some of the cases that we've done fairly recently, we've had returns on their investment that run in excess of 1,000% up to a little over 4,000% return on investment. Obviously, throughout the whole portfolio, they won't be quite that high, because there's some of them that we'll have to negotiate a smaller settlement, and there's some that won't have any value at all. If that's the case, we'll probably resell those to somebody that is looking for a different level of judgment to work on.
Yeah, I think I actually skipped one part of the process.
Okay.
When we do the analysis that we do, it's a high level analysis, but it's not enough for us to have comfort to make a bid. So we'll actually carve out a piece of the portfolio, and there's an intermediary step where we would hire a company like Joe's to dig deeper. So we'll spend more on due diligence to take a deeper dive into assets that, based on our analysis, we feel will tell us whether or not this portfolio will yield, A, B, C, or X, Y, or Z, and then from there back into the pricing. And I know you're going to get into it later about the levels of thoroughness you go through, but I did think it was important that we don't skip that step.
Yeah, and I mean, really what it comes down to, when a guy like Joe wants to get our firm or our organization involved in the next step, and the next step being, look, there's a judgment, where do we go, and what do we need to do to identify those either cash assets or real estate assets or other types of assets to satisfy the judgment. So it's always, and you heard it a lot, but there's a cost-conscious component to this, and there's strategy involved, like Joe had explained, getting the right people in place, because you may be dealing with multiple jurisdictions in order to get at those assets. One of the things that I always like to do is, I figure my client has done whatever work they've done up to this point, and they pretty much know or have a reasonable knowledge of what exists, And once we reach that information ceiling, then it's a matter of saying, okay, what collection steps have been taken up to this point? And Joe hit the nail on the head. If there's been some collections, what are we left with? What's the residual? And that's the delta that we're fighting for. But keeping in mind that we're dealing in a judgment scenario, and so there's a debtor and a creditor, and the creditor would want to know, or we would want to know, in terms of from a settlement standpoint, negotiation standpoint, has there been fraudulent activity involved in any point in the transactional history? More often than not, during the litigation process or the judgment up until judgment's been determined, there may be a finding of fraud, and in that case, and we're going to discuss it at great length later, but fraud is a big issue because it's not dischargeable in a bankruptcy court. So we want to know that, and then if there's issues post judgment, fraudulent conveyance, can we identify those, and is that a leveraging tool in the negotiation process? So these are the three questions we always typically approach any engagement.
Okay, with that, we usually will go ahead and start our initial research, and I'm not going to read all these things, but these are the general steps that we're taking. First thing you've got to do is get the judgment docketed or perfected, and we find a lot of times the bank or the original judgment creditor will file in the jurisdiction where the debtor lives, but not necessarily in the jurisdiction where the debtor's assets are located. I had a case recently, part of the portfolio, where at one time we had 9 different law firms in 9 different states working on the same case at the same time, and that's not nearly as bad as it sounds, because we'd found an asset in this state, assets in that state, assets in this state. We knew there was a bank account over here. We needed to both garnish the account and subpoena the activity out of it, which we'll talk about in a few minutes. But we were hiring specific local counsel to do a specific task to complement the work that our lead attorneys were doing, and pulling together all of the stuff to start executing on assets. And the quicker we could get some money in to pay the legal bills and so forth, the better the clients like us, and the less often they have to reach in their pocket for money or have a cash call to the other investors. So you want to speak about some of the due diligence here?
Yeah, so some of the due diligence, I mean, let's think about it. We're trying to get at the assets, so, and we'll get it, we're going to go into great length where you can get information, but after you're docketing the judgments, you're doing some due diligence, and if due diligence wasn't performed pre-judgment, then there's an opportunity there. But certainly once you've done the due diligence, do you have the proper legal filings, writ of executions against assets? Is there a bankruptcy opportunity? And if so, where does our creditor lie in the grand scheme of other creditors that may be wanting to be satisfied in a bankruptcy situation? Well, once your real estate assets are identified, is there a levying opportunity? And that's something that we would point out for either through with lead counsel or whomever. And then again, back to the fraud issue. Do we see money assets, property assets, whatever being fraudulently conveyed outside of estates from an individual, outside of business entities to other business entities, being, offshore, staying domestically, or coming back domestic from offshore? Those are the types of things that we're trying to point out as service options during this judgment enforcement process.
Point out here where it says settlement negotiations, it appears the judgment debtor has significant assets. If it does look like they've got assets that have liquidity to them, we'll often go in and offer them a significant discount off of the face amount of the judgment to settle the thing without them having to incur legal cost or us. And quite often that is satisfactory once they're convinced that we intend to stay for the duration. Execution on assets or garnishment of brokerage and bank accounts. Let me say this, one of the first things we do when we start our due diligence investigation is we locate the bank accounts throughout the United States and the brokerage, stocks, bonds, and mutual fund houses where our debtors have accounts. And we've been able to do that in compliance with the Graham-Leach-Bliley Act, which is very strict controls over what you can access and what you can't. So we can't get the exact account number or the balance down to the dollar, but I can tell you with an excess of 95% success over the last 15, 20 years that we can pretty well find we have to have the social security number of the debtor or the tax ID or FEIN number of the entity, and with that information we can tell you where their stocks, bonds, and mutual funds are with the brokerage houses and the approximate value of it and where the bank accounts are. It doesn't matter if it's one account or 20 accounts. There's no additional charge for regardless how many accounts there are. Most attorneys seem to think that the value in finding the bank account is you garnish the account, you take the money, and you move on to something else. Not so. The real value in finding the bank accounts is to be able to go in and get at least 24 months of credits and debits. We always subpoena all loan applications and support documents, including tax returns and financial statements. And if it is a commercial loan, they're going to have not only 3 years of personal tax returns and 3 years of personal financial statements, but also 3 years of business loans, financial statements and tax returns. When you've got 3 years of their business records and taxes and 3 years of their personal, you've pretty well got the mother load. And what I'm looking for there is not only assets to have, but I go back and look at the financial statement at the time they made the application for the loan that we have bought with the judgment. And I'm looking to see what assets they put on their financial statement, because the test is, did the bank or mortgage company reasonably rely upon that financial statement in making their decision to make the loan? And if they did reasonably rely on it, and why would they get it if they weren't going to? And we find that the debtor did not own those assets at the time that he gave the financial statement. I always look at it and get kind of puzzled, and I said, well, let me think. I know there's a term for this. There's a legal term. What is that? Oh yes, it's bank fraud. And of course we would never threaten them with charging them with bank fraud, but I do empathize with them sometimes about what a shame it would be if the media picked that up, since they're big business people here in town, and what kind of repercussions it might have on their reputation and credibility within the community. And of course we move right on into another subject, but that seems to get their attention and often helps with settlement negotiations. And as we're going through these things, if y'all have any questions, comments, if you've got experience different than ours, please interact with us and ask us about it. We often learn a lot more from you than you do from us, so I encourage your active participation. Okay. What I have found is that the typical approach that attorneys want to make is, as soon as the judgment is in place, you've got 30 days before, in most states, before you can start executing on the assets to collect them. So first thing they want to do is either get the debtor in for a debtor's exam. Most places it's called a Rule 69 deposition, or they want to send interrogatories, which are written questions, or both. And we've come up with a process that works much better for our clients, so we don't allow the attorneys to do interrogatories until the thing's just about over, and certainly not do depositions, because you're limited in the interrogatories, as we say here. You can't do any follow-up questions. You just have the questions you ask. You can't get a whole lot of detail. And with the depositions, you don't even know what to ask at that point in time. So you're asking the questions based on what you already know about the debtor. And in reality, what you're doing is you're telling the debtor what you know and where you're headed, so they can really go hide the assets. So they never tell the truth, and they never bring all the documents on the subpoena ducis tecum to the depositions. I've been doing these things for years and years, and I've never seen a debtor bring everything that they've been subpoenaed to bring in. So they have all kinds of promises. Oh, you met that bank account. Well, I didn't realize that was the one you were talking about. I said all accounts. My tax returns, well, my accountant hasn't finished the taxes for this year, or last year's return, I think my wife's got those in storage somewhere. I'll get them, don't worry, we'll get them to you. They don't.
Yeah, and tax returns can be, I've seen where the tax returns have been requested, but all we ever get is the face sheet of the tax return, the 1040. Well, if this is a sophisticated business owner, they're not only going to have which, by the way, the Form 1040, if you're not familiar with it, is the individual tax return face sheet. It's very limited information. There's lots of schedules and attachments that go behind that 1040, and if it's a sophisticated business owner, they may have individual filings for their business entities, and those can be very complicated, very detailed, and if there's multiple business entities, there may be multiple business entity tax returns, but they show up at the deposition with just page 1 of the 1040. And if you're not clear in your request saying, I want all tax returns, personal tax returns to include all schedules and attachments and worksheets, as well as business tax return schedules and worksheets, they're just going to show up with that one piece of paper, and it's not helpful at all.
But my opinion is that doing interrogatories and certainly doing depositions early on in a case is not only counterproductive, I think it should be malpractice, because you're telling the debtor where you're headed, and it never brings what you hope it will bring, and it gives them a lot of tools to work with to make their ability to hide assets even better. So until we've recovered about 80% of the assets, except in very unusual circumstances, do we ever do a debtor's exam. And what they're really good for is getting some perjury on the record that you may be able to threaten them with, but the reality is, I don't think I have ever seen a court take a debtor who has committed perjury and move his case up ahead of 300 or 400 criminal cases or civil cases that are on the docket so they can get to your little problem right then. They got to get that docket cleared out, get it cleared out. So the threat of perjury is not something that is very serious to the sophisticated debtor. As we mentioned earlier, a judgment based on fraud is not dischargeable in bankruptcy. And so that's why we're looking for fraud in their applications and so forth. And this, of course, is not the civil fraud where they've fraudulently transferred assets, which is a completely different issue. And in those cases, you can unwind those in nearly every case. So we do comprehensive research from that point on, and we get their addresses. We look at whether or not they're an occupant of the property and are the owner. If they are an occupant but not the owner, we want to know who the owner is, because if they're renting, we want to go to the landlord, get copies of their rental checks, their rental application, see where those checks are drawn on, what banks they're drawn on, and so forth. If it's owned by a business, then you want to research that business to find out how many other rental properties they may own, and so forth. So it's just a matter of connecting all the dots to start getting more and more assets. We typically will subpoena both their landlines and their cell phones, and we can get some wonderful information there. Although used to, if they had offshore accounts, they would have to fax to the offshore bank their instructions for moving any money, or they would fax their local bank and say, this is Joe Dickerson, account number so-and-so, I want to move $500,000 to my bank in the Bahamas or Hong Kong or wherever. Nowadays, with emails and the ability to do voice instructions for wiring, you very seldom see faxes used anymore. But the nice thing about the verbal instructions is two things the bank's going to have. One, they're going to have authorization for who is authorized to give the bank verbal instructions to move money. And secondly, they're going to have a live recording of those instructions, which will be kept for at least 7 years by the bank. I have on numerous occasions subpoenaed those wiring instructions that were verbal, get that along with the written authorization that they had to give the bank and their PIN number authorizing them to move that. You play that tape for a judge, and it's pretty chilling. And I have never, ever failed to get a writ of execution on those assets if they were moved domestically, or it's a great help if they've been moved offshore. So voice recordings are wonderful. Talk about lodging, from charges where we find somebody stayed in a hotel at length. I had a guy that we were trying to negotiate with him to give us his Persian rugs and his antiques to help satisfy about $250,000 worth of his $1.2 million judgment. And he kept saying, of course, we'd got on a first-name basis by now. He said, Joe, I just can't do that. You know, I had to give my new wife those antiques and Persian rugs to get her to sign the doggone prenup. She wouldn't sign it, and now those are her assets. They're not mine, so I can't give them to you.
It's a good one.
Yeah.
So I, being very empathetic, we had obtained his phone records and saw where he had been calling a particular hotel in Las Vegas, and we subpoenaed his credit card records, and on his American Express charge slips, he had charged a penthouse for about 3 nights. He had charged 2 other suites and 3 other single rooms, all on the same credit card for the same period of time. In addition to that, he had charged a limousine and about between $250 and $300 worth of floral bills, all during that period of time. And I said, what does that sound like to me? I think a wedding. Well, that wedding was 2 months before the wedding in Denver that was done for the society page and all of their friends to come out to their home on at the country club. And it was very well publicized wedding because he owned the largest real estate company in town. They had like 28 realtor offices around. So when I looked at these charges and thought, well, maybe we had a wedding in Las Vegas beforehand, I called Clark County, got a copy of the application for the license and a copy of the marriage license, and sure enough, they got married in Las Vegas 2 months before they got married in the civil ceremony in Denver. So his post-nup was a prenup. I mean, his prenup was a post-nup, didn't hold water, and we were able to get all the antiques and Persian rugs and to get his attention. And I had found 128 entities that this guy had. He would use the initials of his holding company and Roman numerals 1 through 128 for each of his investment entities. And we were able to get through those. He had made his secretary's husband president of 28 of those companies, and that poor guy didn't even know he was involved. He just put his name on them. And when the secretary found out her husband was an officer in her boss's shell entities, she went through the ceiling, called me up and said, what do you want to know? And we got tremendous intel from her. Driver's license, well, there's a couple of reasons I want those. One, it helps me prove or disprove homestead. And I'm working a case for Joe right now here in Florida, and the guy keeps claiming that his $500,000 condo in Fort Lauderdale is his homestead, yet the record indicates that he's still living in Chicago and only comes down here occasionally. So we have subpoenaed his card access records to the garage and to his apartment to show that he's only in there maybe once a quarter. And we've already got the information from his home in the Chicago area, and I think we're going to be able to break the homestead claim that he has. Plus, he filed his homestead about 2 months after our judgment was perfected here in Broward County, so we feel pretty confident on that. Yes, sir.
How has the growth of social media made your jobs easier or harder in terms of assessing the viability of a judgment, tracking down, as you were mentioning, you know, is this his homestead? Is he properly living here? Is he just coming out for vacations?
Yeah.
So how is social media affecting your, how's the growth of social media affected your business?
Well, it's amazing what people will brag about on their social media. You know, we just bought a timeshare in Puerto Vallarta and this, that, and the other. There's usually pictures placed on there for their vacations and so forth. And here again, business trips, we can find out a good bit. Husband gets a promotion, the wife needs to brag about it. So we always check as much social media as we can.
Yeah, and the nice thing about social media is it's readily available. If it's a public's, if their profile is set up for public, then it's all right there. You just need to keep in mind as you're doing these comprehensive research engagements, if you're going to walk down that path, you need to take a screen print that documents the date and the time that you pulled down that data, because you and I both know that you can go in and start pulling stuff off of those public sites. Matter of fact, you can even turn it to private so that nobody has access to it. So if you didn't have the foresight to document your research, then you've lost it. So just keep that in mind.
Sorry, guys, as well. So in regards to like them taking their profiles to private, do you have, as part of civil cases and part of these judgments, do you have any ability to subpoena materials from social media that you, like, for example, you encounter all these images of you bragging about his timeshare in the past? Could you go to a court and try to get a subpoena for that information, or?
You could. I mean, you can do a lot of things, but the issue is that now you're dealing with whoever the social media outlet is, and privacy concerns, and having to deal with all that, and that's a whole another can of worms. So hopefully, when you're getting involved in these, they've got a public site that you're able to document your research, and then just part of the negotiation process. You put this in front of them, saying, look, in our world, timing tells a story and change matters. So as I'm going through these dates and times of when these things were posted and where they were at, maybe geography matters, you can build up a timeline, show them pictures saying, look, wow, that's interesting that you said that, because none of these things support what you've just said. That's where the value would come in.
Another route I've used is that if we get a writ of execution to raid their house, because, I'll talk in a minute about how we can get those, but we always ask the judge to put specifically in the writ that we can confiscate their computers at their home or their office and do a forensic analysis thereof, and then you're going to get everything. And we've also, I recently got a cell phone, again, in a case where our debtor had gone to prison for not paying the taxes on the money that he stole from my client, and his daughter had been charged in the civil case with him as an accomplice, but she didn't have any assets to recover, so I let her talk me into becoming an informer for me. And Dad got pretty lengthy sentence, but he beat it. He was only in prison for 2 months and he died, so he didn't have to fully serve his full term. But daughter ended up taking care of the estate for him, so she got her hands on his cell phone, called me. See, she was upset with Dad because they had lived in the hills of Virginia when she was a child, and about 14 years old, she and Mama were going to the grocery store one day, and so they came out to get in Mama's car, and Dad said, no, today I want you to take this car. I said, no, I'm fine with it. I said, today you're going to take this car. Okay, what the hell? So they did. Started down the mountain, around the first or second curve, no brakes, dead center of the tree. Mama was killed, daughter was hurt but lived, and investigation showed that the brakes had been tampered with, and so all of her life growing up, she felt like Dad had killed her mama, and she was pretty PO'd about that. So she went to work for him when she became an adult for the specific purpose of being able to embezzle funds from him to hurt him, and anything else she could do to hurt him. So when he went to prison, she got that cell phone, called me and said, would you like to have Dad's cell phone? I said, yes, matter of fact, I would. She said, I don't know the passwords. I said, don't worry about it. Gave that to Dave, he gave it to
We have
this guy.
a computer forensic specialist. Matter of fact, he testifies as an expert in court. But he's able to get at the data set. He has a lab that he runs. He's able to bypass passwords to get at data sets. And after having obtained a forensic image of it, because that's a big deal, you have to have speak to how you obtain that data, and is it from a custodian of record standpoint, is it a true and accurate representation of what that data showed at the time you took possession of it. So we did that, and we were able to get at that data. So,
And the data in that case revealed that Dad was letting his fingers do the walking. He was banking by cell phone, and we found 2 offshore bank accounts with the date and the amount that he transferred the money over there, and were able to freeze those accounts and ultimately get them released.
And how big, so when you're doing due diligence regarding the obtaining of the information, how much of the threat is the fruit of the poison tree doctrine? So how careful, when regards to obtaining the information that you're using to claim these judgments, how are you making sure that your means of obtaining this information aren't gonna botch your attempt to insert it, to introduce it in court?
So we keep a chain of evidence. If we transferred it from one to the other, just like you did with any other, and we're pretty careful about where we get our information. A lot of it is obtained by subpoena. But in this case, a family member voluntarily gave it to us, and there was no challenge. Dad couldn't really complain about it, so it was fine. Okay, let's move on to vehicles. A lot of information here. We're looking for the lien history or who the lien holder is on any vehicle, whether it's an automobile or an airplane, so we can find out who did the financing on it and how long they've owned it, and we'll go to the finance company again. All the details are in the application, not necessarily in the loan documents, so we always want the application for the loans and their support documents. Business affiliations, part of the comprehensive research. We'll get dozens sometimes of companies. We verify those with social security number or tax ID number, and then from this preliminary research, we verify everything with the Secretary of State or the appropriate agency that has all of the public record information to prove up what we need to there. And then from there, if we need to subpoena corporate minutes or stock certificates, stock transfer ledgers, anything on the LLCs and so forth, we'll subpoena those things to prove up the ownership.
please.
I can't hear anything.
Could you say it a bit louder? I'm sorry.
If they go bankrupt, depends. I find most of the time their bankruptcy schedules are not accurate, and you can get them thrown out because when they go bankrupt during the middle of one of these cases, sometimes you just have to live with it. But we certainly will get our debt filed with the trustee, so that we, depending on what kind of bankruptcy they take, we've got some shot at getting some recovery. But more often than not, they're either omit all of the information or something so we can get it excluded.
So from my standpoint as the buyer, if I may jump in, if we couldn't, between our search and the second level search, and now you're starting to see the layers as he's going through the mirror. If they had assets, you can correct me if I'm wrong here, but if they had assets such that they were worth going after and us spending money to go after, they're likely ineligible for bankruptcy. Is that fair enough? Or we'll find a way to make them eligible. If they didn't, we probably didn't pay much for it anyway. So
I often have had debtors, once we start executing on their assets, they say, Mr. Dickerson, if you don't get off my backside, I'm going to take bankruptcy. And my response is always, get your hat and coat. I'll drive you over. In fact, I've been thinking very seriously about putting you into involuntary bankruptcy anyhow, and I have my client's approval to spend the $35 for the filing fee, so we will get rid of all of our competition. Our judgment's based on debt. Our debt is based on fraud, so it's not dischargeable. So let's go. Never had anybody take me up on that.
I had one where I had to discount it all because there were no assets. And in the UK, the in and out years, they take what's there or you get
Yeah.
it's a real threat.
Yeah. Other thing I've found a lot of times in the bankruptcy, in fact, we've got one right now in Montana, where the debtor did not schedule my client's debt in his bankruptcy schedules, and we're within 30 days of his appeal time for anything, because the bank trustee has already closed the case. And when we took it, we didn't initially know that he was in bankruptcy. When we found out, we had already found that he had transferred about a dozen tractor trailers that he had to his girlfriend, who works for a federal agency, and we found over $500,000 in her bank account. We seriously doubt that she saved that from her savings plan while working for the federal government. So I think we're going to find that those were all assets that were fraudulently transferred to her. We'll be able to get them. Bankruptcy is not necessarily nearly as bad as it sounds on the surface. Sometimes it is. Okay.
You got a question?
Yes.
Yes, sir.
If I could follow up on that a little bit. Taking it back to the point at which you're, I guess, sourcing these judgments and deciding which to go after, how deep do you go into an investigation before you decide it's not worth it? I mean, a lot of what you're talking about here, it seems like a number of things that you can do on the initial search might not cost you a lot of time and money to do, but at a certain point, the judgment can't be enough to support it, or are you only taking judgments to investigate that are over a certain threshold?
Not necessarily. It's a cost-benefit analysis. You know, we have to look at them and find out, you know, what's out there, what can we reasonably expect to get for them when we liquidate those assets. And of course, if it goes to sheriff's auction, we typically don't let the sheriff auction off the assets. We attend the auction and buy the assets out of the auction with a credit bid, and then sell it for fair market value. So, Joe, do you want to speak to that?
Yeah, there's some of it's just intuition. We were talking about one debtor just before lunch who the judgment was $14 million, and he doesn't have any assets anymore. But we're pretty confident that, and we followed. Well, I don't want to say too much, but he owns he did own a fairly reputable pizza franchise, and so you can use Google, and not necessarily social media, but certainly Google, to follow what happened with that franchise. And he, on paper, doesn't own it anymore, but fairly certain the bank didn't lend him $14 million without assets. So there's that aspect of it. Then there's also the aspect of those with high balance loans that maybe become judgments probably also have other assets. Whether you know exactly what they are yet or not, it's likely they're there. And you know, if you ask me if we were buying one asset, one judgment, I should say, and you don't know everything, but you know a few things, would you pay a lot for it, or would you pay more for it? The answer might be no, but across a portfolio, you can start to take some risks. The other thing I would say is different debtor was working on a very large, I don't want to say name, but it was down here in Florida, a very large project that went south, and I don't know, probably right around 2008 and 9, right? 7, 8, 9, somewhere in there. There's a commercial real estate developer. His now judgment is $24 million and accruing more, you know, with the statutory rate. He claims he has nothing, but very simple searches, and meaning searches we can do at our level without going, you know, doing the brain damage that this team here does. That I love hearing the stories, but I don't know how they do it. But even at my level, with the resources I have, I'm able to look him up, see 6 homes, more than one in Florida, so I already know one of these. He can only claim one as his primary home, you know, under the Homestead Act. And I forget the number, 34 LLCs and partnerships, a lot of which have real estate sounding names. So I can look at that and say, you know what, I think this guy who's on paper seems to have nothing has a lot. somewhere, it's just a matter of getting to it. And also, with the use of the internet, we found that he was working on another commercial real estate project, I believe a $400 million project in Florida. So
We're going to be his new partner in that.
yeah. So you can use some deductive reasoning and logic to make, I think, what we would call educated guesses that there's more to go after here. And of course, we're pricing all it in too. And I have to, at the end of the day, accumulate all this information, decide what I'm going to spend, 10, 15, 20,000 on for a deeper dive, not a comprehensive dive, but a deeper dive. So out of 100 judgments, I may take 10 of them that after my research, I said, hey, let's spend some money on, some real money on. And then with that information and then consulting with Joe's team, say, all right, well, we're fairly confident with all the information we know and the deductive logic we want to apply to it, we can collect over time a range of X and may cost us Y. So, our net X profit would be whatever. Let's offer, obviously, a discount to that because we're taking on significant risk. But
Another good thing on the one you're talking about for the 14 million, the debtor and his wife are both judgment debtors on that 14 million case, and the son has taken over the family enterprise of multiple locations of a business. And we just found out that on the son's checking account, Mama is a signature. So we're probably going to be able to get a substantial amount of money from the bank on the accounts that both were fraudulently transferred to the son and that the wife, who's a debtor,
I was going
is
to say,
signed.
I'm no expert, but that sounds like a fraudulent transfer to me.
We'll see. Okay. Professional license, yeah, we'll find out if our debtors have any professional license. And, sometimes we can go to the litigation files, find that they have been sued in their professional capacity, get copies of depositions that were taken in other cases. And some of the best recoveries I've ever made was going back and reading depositions from old cases where the attorneys that were doing those depositions did a very, very poor job in asking questions, and they'd just get a tidbit of information and just let it go. In other words, one guy, they asked him in the deposition, well, tell me about this holding company that you had in Los Angeles. And he said, oh, that was 12 Burger Kings I had, but I sold them. Oh, okay. Well, tell me about the pizza franchise that you had in Virginia. Oh, all the stock in that company is pledged to the bank. Oh, okay. This lawyer moves on. Well, I've got a lot of questions, okay? So you sold all of the Burger King franchises. What'd you get for them? Is it a payout? Did you get cash? Did you own the locations, the real estate? Well, come to find out, he was taking payments on some of the franchises. Some of them he'd sold for cash. He had sold 6 of the pieces of real estate, but the other 6 he still owned and was leasing them to the franchisors who had bought the franchise from him. So we took all 6 pieces of that real estate, and it was all in the San Gabriel Valley of California. So it was very valuable property. And the other attorney in the other case had just totally missed it by not asking enough questions. He had told her that the Pizza Hut company, that stock was pledged, but she didn't ask pledged for how much. Is the debt paid down? And come to find out there was only $50,000 left on the debt on the stock. So my client paid the $50,000, and we did a writ of execution and got all of his stock in all 12 of the Pizza Huts. Pretty cheap investment.
And just to add here, so I'm looking at professional licenses, even at our very, what I'll call kindergarten level compared to what these guys do. We were able to find out that looking at one of the debtors had a real estate license. So we looked her up and found out that she doesn't just have a real estate license, she owns a Caldwell Banker franchise. In, I don't know, it was Maryland or Virginia, it was right in that corner. And so we were able to deduce that, hey, this is worth a little more than, you know, someone who otherwise doesn't look like they have many assets, so.
We've sold 2 of our rental properties and fixing to get the 3rd one closed
Yep.
before the end of the month. Okay, in the comprehensive reports too, we also get their history on hunting, fishing, license and so forth. And I put this in here intentionally because it's one of my favorite stories. I noticed that my debtor had renewed his fishing license, his hunting license in Alaska for the last 9 years. Well, you don't go to Alaska hunting for 9 years in a row unless you're a pretty serious hunter. Probably a trophy hunter, and probably have expensive rifles. So along with that information and some other, we were able to get a writ of execution to raid his house with the sheriff's department. So first thing we took was all of his high-powered rifles, and then the next thing is we had a moving van with us to put everything into bonded storage until the sheriff's sale. So I directed the moving guys to take his white polar bear, who was standing 6, 7 foot high with, you know, one claw up in the air like this. And the sheriff had told the guy, you can stay during the execution of the writ, but you sit down right over here and you stay there and you don't interfere with the execution of the writ, or we'll put you in jail for interfering with a court order. So sit down and be quiet. Well, he watched us wrap up his polar bear, and then I told the movers, I said, okay, let's get him in a crate so he's well protected, and as soon as you get him out into the van, I want to take the moose and the caribou, and I started pointing out trophies, and this guy couldn't take it any longer. He jumped up and he said, you SOB, what's it going to take to get you off my posterior? And I explained to him that, you know, I wished him no ill will. In fact, I wished him every success in the world, because he and I are now business partners, and I'm going to take everything he makes for the rest of his life until we're paid off. And, you know, if he doesn't enjoy having me as a partner, I'll go away. All I want is 100% plus cost and interest. And we stood there in his family room and got a 100% settlement that was funded in less than 10 days. And we never had to load the van with anything, just from finding that hunting license and it leading to one thing that led to another, it led to another. I don't know. Has anybody read The Art of War by Sun Wu? Okay. One of my favorite books. Sun Wu says, take from a man that which he cherishes, and he will follow your ways. And I figured out with this guy what he cherished was his trophies, and sure enough, it worked very well. Bankruptcies, I think we pretty well talked about those. As most of you know, you can only take a bankruptcy once every 7 years in the United States. Yet I have found in a fairly recent case where our debtor had 3 concurrent bankruptcies going, and when we looked into them, we found what he had done is he had filed one in Los Angeles district, one in the Houston district, and one in, I think it was Chicago. But he'd moved from one bankruptcy court district to another, and the bankruptcy courts do not apparently cross-check when somebody files in their district. They check their district to see if he has any other bankruptcies pending, but they don't check other districts. If they do, they don't do a very thorough job. So just something to be aware of, because that certainly was fraud. Liens and judgments, pretty straightforward there. We can get social security numbers, all kinds of good information, but most importantly, you can get the name of the creditor to go in for these broad subpoenas to get background information, taxes and financial statements and so forth. Same thing off of property. You know, if it's rental property, you want to check the company, see what all it's got. If they have a corporation, we very seldom ever try to pierce the corporate veil. You hear about that all the time, the attorneys want to pierce the corporate veil. Instead, we get a turnover order for the stock and just take the stock away from the debtor. Then my client owns the company, and although they have no money, somehow within a matter of a week or 10 days, they have an aunt or a grandma or somebody that can come up with just enough money, and we always are willing to sell them their own stock back for just what's owed on the judgment. And it's an excellent tool. I'm sorry?
I had one of those, and the guy said, well, this is a trading company, there's nothing in it, nobody is going to get a penny for this because it's going to go up for public auction. So I said, that's fine. A friend of mine wanted to buy a business like that, right? At which stage he went, here's the money.
Well, you got to have a little fun with these things.
Very good.
Yes, sir.
So another thing you mentioned about, taking away like the really important kind of things people cherish, taking away the really sentimental items. Another aspect, as Sun Tzu says, never put a man in a corner because that's when he's going to fight the hardest. Is there a risk to, for example, like going after that polar bear where if you just piss him off, he's just going to try, whereas he might be willing to let's just get this over with and settle. Now he's going to be now he's just going to be trying to hurt you as much as he can, regardless of how much loss he's going to take.
Yeah, well, somebody's motivation's their motivation. I mean, we're already at the point, everything we've talked about, we're already at the point where judgment's been filed. You're already back into a quarter. We're just pointing out the issues that you just want to hide. So I don't really care.
All of this kind of leads up to this slide here, and I know it's difficult.
Yeah, we have handouts.
Who came in after we passed those out? Would you be sure everybody gets one?
Just backing up a second, we haven't put them in a corner. So not to overanalyze that analogy, but we've put them, their back is against the wall, but there's ways out, and the ways out are, like Joe said with the polar bear guy. He didn't want that way out, but it's a way out. So
Yeah.
You're forcing him to choose the path, but it's not like there is no path. There's a path.
Yeah. Sometimes there's a path of least resistance, and sometimes there's a different path. Okay. Let's go over this rather quickly because we're getting down to the end. And then if y'all have any questions about this after it's over, I'll be happy to send this to you and the backup slides that go with it.
We only have 5 minutes.
Yeah. All of the lines across the top are places that you can go to find out where your target's bank accounts are located. The one on the far right is a private vendor. We usually bypass these others because it's time and money, and we'll spend the money with a private vendor to find out where their bank accounts are located. The second line, again, it's going toward the center where it says bank accounts and intermediary banks. One of my favorites up in the upper left-hand corner, just one across where it says defense attorney. As soon as the other side hires an attorney to represent them against us so we can't take their client's assets, the first thing I do is garnish the attorney's trust account. I've got one attorney 3 times in 3 weeks for $5,000 a week, so we picked up a quick $15,000 of cash that belonged to the debtor that he was paying his attorney's retainer with. And that always sets the stage for a harmonious relationship. But kind of fun. Once you find the bank accounts, then if you go down to the lower left-hand side, you see we will subpoena the bank for safe deposit box records, and if they have one, I have on several occasions been able to just go out with the sheriff's department, drill the safe deposit box, and we'll get jewelry, trust instruments, wills, bonds, title to offshore real estate and so forth. I've recovered all those things out of safe deposit boxes. The next 2 lines over is we'll subpoena all credits for 24 months and all debits for 24 months. And with the credits, we want to know their source of income. If there's money coming in from Exxon every month, I don't want the monthly check. I want their investment in Exxon stock. So you connect the dot and you go to the dots behind that. If they've got rental checks coming in, I don't want the rental check from their tenant. I want to own the real estate that is producing the rental income. The next one over is all debits. So if they're spending money, we want to follow the wire transfers to see where they're going, get the checks, see what they're purchasing with it, see what they're investing in. Maybe it's a country club membership. I sold a country club membership for $5,000 a couple of years ago because it was negotiable, and It was just clear money, and they had people standing in line to get memberships into that particular club. Loan applications and support documents, we've talked about that and the kind of information you can get from it. Over on the right side, the lender for the home loans. One thing I always want to do when we identify the homeowner, if they're making payments on the home, who in here is buying your home? Anybody else? So if you're buying your home, you're making payments on it, right? Your payment instrument consists of four things. What is it?
Principal interest.
Principal, interest,
Tax.
taxes, and insurance. So they're escrowing for taxes to be sure that don't lose their collateral to the tax sale. They're escrowing for insurance to be sure if the house burns down, they get their money, right? So does it make sense if the lender is escrowing for insurance, they know the name of the insurance company, they know the address of the insurance company, and they know the policy number, right? So we subpoena that from the lender. Once we get that, the next subpoena goes to the insurance company for a copy of the homeowner's policy with all addendums, amendments, and schedules thereto. And upon that, you will find, where it is not in public record anywhere, the list of the furs, the jewelry, the Rolex, the antiques, the stamp collection, the gun collection, and all of their valuable personal property have never, ever, ever been turned down by a court to get a writ of execution to raid their house and confiscate those items. Once you're legally in the house, you can take any other non-exempt assets to help satisfy your judgment. So that's a beautiful tool, and 98% of the time, the attorneys representing the creditor will skip over those. So this is kind of the mother lode. This is the way we run most all of our cases once we gather all of this preliminary information. I want to take one other minute and read to you a quick little story that I'm rather fond of, and I think you'll see why. He was 11 years old and went fishing every chance he got from the dock at the family's cabin on an island in the middle of the lake. On the day before bass season opened, he and his father were fishing early in the evening, catching sunfish and perch with worms. Then he tied on a small silver lure and practiced casting. The lure struck the water and caused colored ripples in the sunset, and then silver ripples as the moon rose over the lake. When his pole doubled over, he knew something huge was on the other end. His father watched with admiration as his young boy skillfully worked the fish alongside the dock. The boy and his father looked at the handsome fish, gills playing back and forth in the moonlight. The father lit a match and looked at his watch. It was 10 p.m., 2 hours before the season opened for the bass. He looked at the fish, he looked at the boy. "You got to put it back, son," said the father. "But Dad," cried the boy. "There'll be other fish," said the father, "but not as big as this one, Dad." He looked around the lake, and no other fishermen or boats were anywhere to be seen around in the moonlight. He looked again at his father. Even though no one had been there to see them, nor could anyone ever know what time he caught that fish, the boy could tell from the clarity of his father's voice that the decision was just not negotiable. So he slowly worked the hook from the lip of the huge fish and lowered it back into the water. The creature swished its powerful body and disappeared into the lake. The boy suspected that he would never again see such a grand fish. That was 34 years ago. Today, the boy is a successful investor. His father's cabin is still there on the island in the middle of the lake, and he now takes his own son and daughters fishing from that very same dock. And he was right. He never again caught such a magnificent fish as the one he landed that night so long ago. But he does see that fish, the same one, again and again and again. every time he comes up against the question of ethics. For his father had taught him, ethics are simply a matter of right and wrong. It's only the practice of ethics that's difficult. Do we do the right thing when no one's looking? Do we refuse to cut corners and use the information we know we're not supposed to have? Or refuse to trade in stocks and information that we know we're not supposed to have access to? We would if we were taught to put the fish back when we were young, for we would have learned the truth. The decision to do right lives fragrant in our memory. It's the story that we will proudly tell our friends and our grandchildren, not about how we had a chance to beat the system and took it, but about how we did the right thing and were forever strengthened. Thank you for your time. We've enjoyed being with you. If we can ever be of service, let us hear from you.